Hi, everybody. My name is Nancy Sanchez, and I'm the Community Outreach Coordinator with TPA. I am excited to have you join us today with the wonderful Lindsay Bowen, who's an attorney for podcasters. I'm going to quickly go through a slide deck and then turn it over. Please note during the webinar, if you do have a question, we prefer that you use the Q&A box. It just makes it easier for us to be able to address all questions and make sure we're not missing anything versus in the chat. So if you could please direct questions to the Q&A box, that would be super helpful. All questions will be answered towards the end of the webinar.
If they're answered at all, it will be at the end of the webinar.
Wonderful. Let's get started.
Hi, everyone. I'm Lindsay Bowen.
One second. Let me just quickly go through the deck.
Told me,
Sorry, Lindsay.
No,
Don't worry.
This is my fault, not Nancy's.
Not a problem. All right. Thank you, everybody. We want to thank Wendry, who's our community building sponsor. Just some upcoming events for you to know about. On April 16th, we have our annual membership meeting. On the 21st, it's using your podcasting for activism with DeRay McKesson, who is a dear friend of mine and also a Bowdoin alum. On May 14th, we have 360 podcast deals and how deals are changing in this 2025 year. So please join us for those upcoming events and many more to come soon. If you are new to TPA or know somebody who should join us, make sure to use code TPA25 and you get 25% discount off your first year of membership. If you're not following us on social media, please make sure to do so. Here are all the ways to connect with us, and we are always looking to grow our community. And that's it from us. I will stop sharing and turn it over to Lindsay. So great webinar.
Thank you so much. Hi, everybody. I'm Lindsay Bowen. I looked at the participants and saw a few familiar faces, which is nice to see. Very quickly, I'm an attorney. I hyper specialize in podcasting. All my clients are either podcasters, podcast networks, podcast ad tech companies, podcast marketers. If I've forgotten anyone, I apologize, or anyone's type of business, I apologize if you're on the call. And Nancy, once I start this slideshow, I'm not going to be able to see the Q&A, unfortunately. So at some point, I'll either stop the slideshow for that portion, or you can maybe read the questions to me. I have been working with podcasts since about 2016. Before that, I was a litigator, an entertainment litigator at some large firms, including Cravath, Swaine and Moore, and Jenner and Block, which is in the news these days. I did a lot of copyright litigation against music pirates for Jay-Z, dealing with royalty and copyright disputes. So I've seen all sides of these sort of issues that we're about to talk about, and some slight evolution in the law in the past 10 years or so. But we're going to get right into this presentation. It was originally developed for Podcast Movement a year ago, which was only a 30-minute time slot. So I'm happy to be able to sort of spread out and get a little more in depth on some issues. We may not have time for questions at the end, but I sincerely hope that we do. So please direct your questions to the Q&A box rather than the chat. All right. So I'm going to set this up a little bit more than I normally do to talk about, fair use in podcasting and why it's so important. It's really one of the questions I get the most, and I see that people have the most misconceptions about even fairly sophisticated creators and business owners and executives. Very recently, someone who creates limited series journalistic podcasts, whose name talked to me about something she had done recently, something she had done back in 2018 that might be made into a television series. And she said, "Oh, I couldn't afford a lawyer back then, so I just fair used it." Fair using it is not a thing. That's like saying, I couldn't afford a lawyer, so I just right to remain silent and it. You can't just, or I couldn't afford a lawyer, so I just second amended it. it's a legal concept. It can be applied correctly or incorrectly. But generally, when someone says, I just fair used it, means I use something in my podcast without permission and hope I don't get sued. And that's what we're trying to avoid here. So let me share my screen and we'll get started. All right. A little peek behind the curtain. And here we go. No fair. Let's talk about fair use. Now, this is, again, at Podcast Movement, there's a little bit more interactivity. I give the same class for college and graduate school courses. So sometimes people are able to shout questions at me. Please don't today. But what is fair use? I'm hoping that the people here on this call can sort of answer this question for themselves, but I'll give you some options. So, is fair use a legal defense to copyright infringement? Is fair use an important but nuanced First Amendment doctrine? Is fair use the right to hire a lawyer? Is fair use a tricky area that even judges very often get wrong? If judges get it wrong and lawyers get it wrong, creators and podcasters and executives, can be counted on to get it wrong. E, all of the above, it's this one. So I'm going to give you a minute to think through, all five of these choices, and certainly hope that you land on E. Okay, wait, copyright infringement. I saw the word copyright infringement somewhere in that list. What is that? Oh boy, we're starting from scratch. Okay. Copyright infringement, in its really most basic definition, and this is oversimplifying, is using any copyrighted work without permission. What's a copyrighted work? You do not have to register something with a office in Washington or anywhere else for work to be copyrighted. You don't even have to put the C in a circle and the year for something to be copyrighted. Anytime you have a work of authorship that's fixed in any medium, that is copyrighted. So, for example, this recording of this Zoom session, this is copyrighted actually by TPA because they're the ones who hit record on this this time. My notes that I've written for this section are copyrighted. They have a very different level of protection from other things because they're unpublished, and we may have time to touch on that in the future. Anytime that you record a podcast, even before you publish it, even before you edit it and get it ready for being published, it's copyrighted. So using a copyrighted work without permission typically is copyright infringement. But wait a second. What about? So I hear this a lot because that sounds very broad. That anything that someone else has created, if you use it without permission, is copyright infringement. And I get a lot of objections when I say that, especially when I then make it a little bit scarier and say that the fines for copyright infringement, if you're found liable in court, can be up to $150,000 for work infringed. So what about the fact that I didn't know it was copyrighted? No. What about the fact that I only used 30 seconds? No, still a problem. What about the fact that the bass player from the band gave me permission to use this song? No, the bass player from the band might not own the copyrights. Probably it's the record label. I found this on YouTube or on TikTok. It can't be copyrighted. No, just because someone else infringed didn't mean that you didn't infringe. Okay, so there aren't a lot of legitimate defenses that people think exist to copyright. Not a certain period of time, not permission from someone who may not actually be the rights holder in this situation, and not the fact that it was easy to do. Those are not defenses. So fair use is a defense to copyright infringement. You'd probably like to know more about that, and I'm glad of it. Fair use is a legal doctrine in the United States, very similar to a doctrine in the UK called fair dealing. that's derived from the First Amendment, and it's designed to protect important societal functions like criticism, parody, commentary, news reporting, teaching, scholarship, research, and again, this is a pretty nuanced idea, but the simplest way I can put it is any transformative artistic or editorial efforts. Now, I mentioned that this is derived from the First Amendment, and here's why, right? Under the First Amendment, we have freedom of speech. If everything is copyrighted, and if the owner of that copyrighted work can basically stop you from using it or make you pay big money if you use it without permission, how can we have true freedom of speech, especially in today's world where corporate media owns more and more and more? That's exactly what the doctrine of fair use, which is centuries old at this point, is has been developed to address. It sort of eases the pressure a little bit of our pretty intense copyright regime in this country and makes sure that we're able to have freedom of expression. So fair use is specifically pointed at things that society thinks is good and society thinks is important to be defended by the First Amendment that may otherwise be hard to do without this exception to copyright. So criticism, for example, if you spend a lot of money putting out a film, putting out a podcast, and there are reviewers on YouTube or television or anywhere else who probably didn't like your movie. Maybe they don't like movies like this. This is a highfalutin reviewer in your Marvel Studios. Are you going to license them to use a clip of your movie in their review show if you know they're going to trash it? No, probably not. And that's why, in order to foster that kind of discussion and freedom of thought, we need to have fair use for criticism. Same with parody, except for the fact that everyone loves Weird Al, former client, no big deal. That people aren't going to license parodies of their work if they're being made fun of. It's just not a common thing. They're not going to give permission for that. Commentary can be the same, and news reporting. Sadly, these days we're seeing how the news media can be stifled in many ways. Certainly, we don't want the news media to be stifled with threats of copyright lawsuits from the people being reported on. Teaching is not the kind of thing that copyright owners might want to stop, but it is a very important societal function. Scholarship, research outside of teaching, and what I said before, these transformative artistic and editorial efforts. This is what gets the most attention in fair use analysis and doctrine, and this is what a lot of the big federal court and Supreme Court cases are about. So we'll get into that some. And podcasts, right? Podcasts are an important societal function. That has to be here. We're all podcasters. We understand how podcasts have moved an election. We understand podcasts are the best medium. It should just be on this list. Well, not exactly. If what you're doing with your podcast achieves any of these functions, perhaps you'll be covered by fair use and perhaps not. Obviously, there's a lot of review, podcast, criticism, commentary, all of these you see in podcasts every day. Perhaps some folks here are working on these kind of shows. It can be protected, but the medium itself is not a guarantee of protection or a sign that you'll be protected less. Okay, well, I think using AC/DC's Back in Black as the theme song for my podcast is artistically important and true. Stop. There is this idea of subjectivity in podcasting, and we will talk about it soon. But just because you think something might be artistically important and an important societal function doesn't mean the law does. And I use this exact question or this exact example because a very well-known founded cornerstone member of the podcast community actually did this when he started his show 800 episodes ago. He had Back in Black as his theme song, and he now tells his many, many thousands of partners that he works with every day not to do what he did. I'd love if you know who it is, say something in the chat. I'll look later. Don't say who it is, just say that you know. All right. What is the legal analysis that would enable us to tell if we could use AC/DC's Back in Black as the theme song for our podcast or anything else? Here it is. There are 4 factors that we use for determining whether a use is fair use in the US. And here are the 4 factors. The purpose and character of the infringing use, meaning what are you trying to do with your use? Does it fall into any of those categories? Parody, criticism, news reporting, analysis, research, teaching, or transformative use? Is the use you're using different from the original use? So here's where we get to the next factor, which is the nature of the infringed work, which can be boiled down mainly to, is this the kind of thing that was intended to be protected by copyright? This second factor is almost always decided against the second user or the junior user, which in this case, what we're describing would be the podcaster who wants to use something created by someone else. Maybe it's music, maybe it's very often I'll see snippets from news reports being used to illustrate things in factual podcasts. If your use ends up being closer to the original use, the closer it is, the less likely you're going to be found as a fair use. We're going to go through all of these in order, though. Don't worry. This is just the summary. The third factor is the amount and substantiality of the portion used. How much of the original work did you put in your work, and how core was it to the center of that work? And then the last factor, the fourth factor, is very important. It's the effect of the use on the value of the copyrighted work or the potential value of it. And we'll get into it, but basically, are you costing the original creator money with what you're doing or an opportunity with what you're doing? Okay, so we've gone through the 4 factors. So does it mean now that we know the 4 factors, are you done? Can you hang up? Are we done here? If you check all 4 boxes, then nobody can sue you, right? No. We're going to get to the 4 factors in a minute, but this is the most important thing to know. So you can take a screenshot of the next slide. I actually changed this to screenshot, I thought. I did. Okay, here it is. Even if you win on all 4 factors in court, you will be out a ton of money. And that is because fair use is a defense to copyright infringement. In fact, it's what we call an affirmative defense. Now, what that means is you can't even say the words fair use in court until you have been sued. First, you got a letter from a lawyer. Then you hired another lawyer to answer that letter. And you went back and forth for a while. Then the other side filed the lawsuit. They're already spending tens of thousands of dollars. If they want to settle with you, you're going to be spending tens of thousands of dollars just to pay for their lawyers. The first phase in litigation is generally called a motion to dismiss. That can be many tens of thousands of dollars to get through that phase. Then you go through discovery when you're looking at the facts of the lawsuit. Perhaps many of you have heard of discovery. Now we're starting to get, if you're in New York and California, hundreds of thousands of dollars. It's only at the summary judgment stage, which is after both sides have had a chance to research the materials that the other side has in their possession, look at the facts. It's very expensive to get these materials over back and forth to have lawyers analyze it. Then you get to raise the fair use defense. So you are in the most expensive part of litigation before you even get to bring this up. And that can cost you hundreds of thousands of dollars. So what we want when we're analyzing our own fair uses of work is we want to be so clearly in the center of fair use that no one's going to try to sue us, that they're going to see it's a waste of time from the beginning, or we're going to settle quickly. Those are our 2 big choices. Oh God, that's depressing, right? Yeah. That's where I want you to be. I want you to realize how scary and depressing copyright infringement is and how hard it is to prove fair use. So this is basically what I said before. We want our fair use to be undeniable on so many factors as possible that it's not worth sending or escalating that email from, a junior attorney or a contracts person at a record label, that they look through your list, they look through your use and they think about it and say, yeah, there's no way we're winning this case. Maybe we'll write a cease and desist letter, but we're not taking this person to court. Or maybe they don't even write the cease and desist letter because what they're doing is so undeniably, what you're doing is so undeniably fair use. Okay. Excuse me. So the thing to know about these four factors is you don't have to prove that you win on all four factors to have fair use. It's not even majority wins, right? If you win on three and lose on one, that is fair use. What judges look at and what these in-house lawyers who are deciding whether to bring a suit or not look at is the degree with which you win or lose each factor. You could win on just one factor. Often factor one, the nature of your use, or factor four, whether you're harming the market for the other person's use, will be the end of the analysis. You don't have to win on all four. You can win on just one. And you could have a weak case on all four factors and still lose. Let's go through the factors. Now, I'm going to start with factor two, which is a little bit out of order. The reason why is because it's the easiest one. We barely have to think about it. If you, again, are the junior user on factor two, you lose. The nature of the infringed work. Is this the kind of thing that is designed to be protected by copyright? So just assume that if you're the junior user, factor two is going to be a loss for you, and that you're going to try to really emphasize staying within the bounds of fair use for factors 1, 3, and 4. Now, sometimes factor two is a little bit in your favor. Certainly news reporting, fresh news reporting, that's, you can't copyright facts. You can't copyright the news. You can't copyright baseball scores. So if you are using copyrighted works that was intended to be hot news and you're using them in some other way, really, we're going to concentrate on that some other way, on that factor one use. But factor two will not go quite as strongly against you. If something is in the public domain, if something is like truly not copyrightable, then you're not even talking about fair use in the first place because you're not a copyright infringer. But in the world where everything is copyrighted, we're looking at the nature of the infringed work. There is a new wrinkle in fair use analysis that came from the Supreme Court 2 years ago, which is they look to see how similar the original use is and the newest use. And so that can make factor two, a little more interesting than it used to be, but it's really not determinative of fair use or not. And we'll get to that in a bit. Okay, factor one. Now we're in the meat. Now we're in the more important stuff. What is the purpose and character of the infringing use? So this is where we look at that list, right? But nonprofit educational and non-commercial uses do better in factor one. And I mentioned nonprofit educational, right? There are a lot of for-profit educational, like Podcast Movement, for example. It's educational. When I give this speech or when there's any other kind of presentation that happens at Podcast Movement, that's not necessarily a win just because education is happening. It is a commercial enterprise. TPA is a not-for-profit. That's a little different. Non-commercial uses in general, public media, anything that's sort of volunteerism, those are non-commercial uses, and they can win on factor one. Also, parody, commentary, and criticism. We talked about these three things specifically at the top because it's sort of obvious to understand why it's important under the First Amendment for these areas to have a little bit of leeway. What the? Okay. So I'm going to talk about transformative uses. Um, let's see. Okay. Um, Parody, pretty simple. Commentary, pretty simple. Education or non-commercial use, pretty simple. What is a transformative use? Transformative uses are more likely to be considered fair uses. And a transformative use is something that adds something new with a further purpose or different character and doesn't substitute for the original use of the work. Now, this is straight from the 2023 Supreme Court case I just told you about. And it's worth talking about that case and some cases that led up to it. It's got some pretty simple works at issue. Prince. Everyone knows Prince. Everyone loves Prince. I'm sitting in front of a purple screen, so that's a little appropriate, I guess. There was a photographer, her last name is Goldsmith, who took a picture of Prince for Vanity Fair in 1984. She was paid $400 for the photo by Vanity Fair, and it was a one-time use. Andy Warhol took that photo and made a screen print of it. It looks pretty much like it looks like a t-shirt, like it was very purple, as you might expect. And then Vanity Fair used that Andy Warhol piece in their special edition or in their magazine at the time. Years later, another magazine company put out, when Prince died, put out a special commemorative edition about Prince and used the Andy Warhol artwork on its cover, and the photographer sued. Um, Eventually, the photographer won and the magazine company lost. But the magazine company had been arguing transformative use. They said that by taking a black and white photo and turning it into a purple and white screen print and putting that special Andy Warhol stank on it, that the work was transformed. The Supreme Court didn't disagree. Even that little bit of work, taking a black and white photo and turning it into a purple and white screen print, can be transformative enough because it added a different purpose, a different character, and didn't substitute for the original use of the work. There was another series of cases before that involving the artist Jeff Koons, who was also sued by a photographer. This happened a lot. Jeff Koons' work was taking a photographer's work off Instagram of flood victims in the Caribbean and of Rastafarians, and just taking a blue Sharpie and like marking out the eyes and writing some things on it. A little bit like Smiley in Do the Right Thing, if I've got some Gen Xers on this seminar. Um, that's not much, right? He took a photo and just scribbled on it. But the Second Circuit in New York, kind of the most important circuit outside of the Ninth Circuit in California and the Supreme Court for copyright, just because so much creativity happens in New York and California. The Second Circuit said that this was fair use. And a lot of people thought this was really the high watermark for fair use because he barely did any changes, right? He like wrote one word on it or marked up the eyes. Kind of the same with Andy Warhol. That's not a whole lot of transformation. You can think of in your own work in podcasting, if you are using a news blurb from a TV news report about a murder, and you're doing a true crime investigation that is set in the city where this news report came from, and you're just using it to introduce the idea that, oh, we're in Atlanta now. You're transforming the use, right? You're not, it's 78 in Atlanta this morning. You're not telling the people in Atlanta what the weather is that morning. You are setting the scene for your podcast. That is a transformative use. To get back to the Andy Warhol case, the reason the photographer won or against the second magazine is because they took the Andy Warhol artwork and put it on the front of a magazine, which is exactly what the photographer was doing originally. And how she makes her money is by licensing things to magazines. So you'll see that's a little bit of factor two coming back into our analysis, that the work, the purpose and character of the infringing use and the purpose and character of the original use was exactly the same, substituted for the original use of the work. I like to give a couple of examples from the early 2000s when I talk about transformative use to show it can be also taking something away, not just adding. One is a webcomic that is not around anymore. I think it's still available, but it's not updated. It was called The Nietzsche Family Circus. And when I talk about family circus on college campuses now, they look at me like, "What's a newspaper?" But Family Circus from the 60s through the 90s was a very family friendly, treacly circus comic strip with a bunch of chubby cherub-like children getting up to adorable but very not intense activities, like people who thought that Dennis the Menace was way too shocking and outrageous read Family Circus. So the webcomic Nietzsche Family Circus took these beautiful little round panel drawings of a kid whispering in church, but would put these, incredibly dark and intense Nietzsche quotes under them. So just by adding that line, they absolutely changed the purpose of the original comic, even though they didn't change a pixel of the original artwork. There's another one I really liked called Garfield minus Garfield, which did the same thing. Garfield minus Garfield. What is Garfield minus Garfield? Garfield minus Garfield removes Garfield from the Garfield comic strips in order to reveal the existential angst of a certain young Mr. John Arbuckle. It's a journey deep into the mind of an isolated young everyman as he fights a losing battle against lonely depression in a quiet American suburb. And this is what it is. So you'll see that they literally did nothing but erase Garfield and had John talking to himself. But it absolutely adds and changes the character of the original work. To me, this is the high watermark of fair use. Not only do I think this particular webcomic is very funny, uh, it shows you how all you can with just all you have to do is just delete one aspect and you have engaged in a transformative use. Now, some of you may be thinking, did I just commit copyright infringement? Right? I just used that web comic, which used the original comic without changing it whatsoever, and put it, on this presentation. I did not infringe because this is an educational use for a not-for-profit institution. It's also strongly transformative, and this is an example that you'll be able to use in your own creation of podcasts when you think about this analysis. I'm not telling the story of Garfield hating Mondays and loving lasagna. I'm not even telling the story of the deranged John Arbuckle and how it shows the complete collapse of capitalism and consumer culture. I'm giving a fair use panel. So I am not using under factor one the same purpose as Jim Davis or this webcomic creator, and I am transforming the use, I would say strongly so. Okay, parody. We talked about parody a little bit in our first explanation of factor one. And I said it's one of the easy ones, right? It's easy to understand why parody would be protected by fair use. Also, parody is a normal English word. So you probably are familiar with the word and you think you know what it means. Maybe. Parody means a little something different to judges and lawyers than it does to everybody else. Okay. So under these cases, when judges have hard cases make bad law, they say, right? When judges have to decide on some of these more abstract concepts, they make a call, and something called precedent is created from that. The next judge will look at what the first one did and use that as either persuasive precedent or sometimes binding precedent. If they're a lower court and the Supreme Court or a circuit court decided the same question, they have to do what that other judge did, what that other panel of judges did. So judges, through this case law, have created an important legal distinction between parody and satire. Parody, according to a judge, makes fun of the original work, where satire is just sort of making fun of society in general. So you're making fun of the original work, not anyone else. There was a case, this comes up a lot with Dr. Seuss. The estate of Theodore Geisel, and we'll maybe get to it later, is like the estate of Prince, very protective of its copyrights. And since I'm in Atlanta, like the Martin Luther King Heritage Foundation, I think it's called, or the foundation, they're very protective over copyrights. Um, the So there was a cookbook that no, there a cookbook that was basically written in Dr. Seuss language, but was also making fun of. Sorry, I'm getting my facts confused. Jerry Seinfeld's girlfriend wrote a cookbook. Someone put out a parody of it written in Dr. Seuss language, and with some Dr. Seuss photos. The Theodore Geisel Foundation sued. And they said, but this is parody. We're making fun of Jerry Seinfeld and his wife. We're protected by fair use. And the Dr. Seuss lawyers said, no, you are not, because you're not making fun of Dr. Seuss. And the thing that you're infringing on is Dr. Seuss. You are engaging in satire. You're using our work to satirize society in general, and Jerry Seinfeld and his wife or girlfriend specifically, but you're not parodying us, so you need our permission. So that is the difference in parody and satire. So if you use Dr. Seuss lines in a diss track, you better be beefing with Theodore Geisel himself, not Drake. Factor 3 is the amount and substantiality of the portion used. So this is where people get messed up a lot and think that there might be a 30-second safe harbor. You'll hear this word safe harbor used a lot for music. If I use less than 30 seconds of a song, I'm safe. If I use less than 30 seconds of a newsreel or news clip, I'm safe. No, there is no 30-second safe harbor. Instead, we look at how much of the original work you used compared to how long, how big, however you measure it, that original work was. I've worked on a podcast recently that was Ambi nominated, I'm happy to say, that used some segments of a television documentary about missiles from the 50s. But it never used more than a couple of seconds at a time. So you would compare that couple of seconds to the 30-minute documentary. That's a very small portion of the work. If you were to use 30 seconds of a 2-minute and 30-second song, you're using a pretty big portion of the work. It doesn't matter how long your work is. So if you have a 2-minute song and 30 seconds of them are from something else, or it's the whole song on a loop. That's your main hook is from somewhere else. It doesn't matter that your song was only 2 minutes. It matters how long the other thing was. So if you use a very small portion of a copyrighted, I don't know, say hour-long symphony, you're much better off than if you use a 30-second portion of a short pop song. The other part of this factor 3, right, the amount and substantiality of the portion used. By substantiality, we mean, are you using the heart of the work? And this came out in a case in the 70s with The Nation magazine involving Richard Nixon and Gerald Ford. Gerald Ford, of course, was Nixon's vice president, became president after Nixon resigned, and then pardoned Nixon. And a lot of people at the time were outraged, thought the fix was in, didn't understand why someone who was thought to be as honorable as Ford would do this. And Gerald Ford published a biography. And in this biography, he discussed why he made this decision to pardon Nixon. A few days before the biography was published, the Nation magazine, which is a liberal magazine, got a hold of an advanced copy of the book and published that entire page from the book that discussed the pardon decision. The publishers sued, I think it was Harper and Row, because that this would depress their book sales, right? So we can analyze this using all the factors we've learned about first, factor one, factor two, factor three. But this case really hinged on factor three. And the nation said, well, we only use one page out of a 250 page book. We didn't use very much, and under factor three, we should win. But the court said you didn't use very much, but you used the heart of the work. In other words, the only reason anybody was going to buy Gerald Ford's autobiography is to find out why he pardoned Nixon. And if they know because they read this, 75-cent magazine, they're not going to buy this $5 book. You'll see how much inflation has affected us since the late 70s. So that is what we mean when we say the substantiality of the portion used. And I believe you could all see why this might be important in your own work. Okay, factor four, also a pretty interesting factor. The effect of the use of upon the potential market or value of the copyrighted work. Did you cost the original person money with your use? So does the unlicensed use harm the existing market or the future market for the copyright owner's original work? Could the use cause substantial harm if it became widespread? So you can certainly think about this in terms of the Nation magazine example. They printed hundreds of thousands of copies of this magazine. Everybody bought a copy of the magazine, maybe was a potential book buyer and didn't buy the book. That was its immediate market. But courts have also said if this is something a creator, the original creator, might do but hasn't done yet. And that came up a lot in the 90s with ringtones. Ringtones were fairly new. You could, download something on the internet that was your favorite song at the time, the 90s, I don't know, Britney Spears song, and use that as the ringtone for your phone. You couldn't actually buy from Universal Music ringtones yet. So defendants would argue, these ringtone companies would argue that they would win under factor four because it wasn't harming the market for Britney Spears or the record label's material because they weren't in that market. But if it's likely that someone could get into that market, that could be a problem. So think about that with podcasting itself. Maybe what you're using something from a lecture series. That's just webinars, let's say. You can't say, well, this is a podcast. They don't make podcasts, so I'm not harming their market. If it's likely that the lecture series company is going to get into podcasting, and these days it is likely that every man, woman, child, dog, and goldfish in America and the world will be getting into podcasting, it's a harder argument to make. And there are also a lot of secondary uses that maybe aren't apparent to people, just to the layman. So film clips, song snippets, sound libraries, these are already licensed for podcast use. So just because you're a podcast and they were a movie doesn't mean that you're going to do well in fair use, because they would say, we make a lot of money licensing clips for television, licensing clips for other media. We also make a license available for podcasts. 0 people have used it yet, but it's available, so you're costing us money. There are conceptual ways to look at this that is more favorable to the podcaster and more favorable to the film library, but that is the argument that the film library is going to make. And actually, I'll get into one of the arguments now, since we have a little more time than I'm used to. How many people are not going to go see the movie because you used a clip from that movie in your podcast? That's sort of the answer that we'd like to make in our letters back and forth to the angry film company's lawyer. And their answer will be, well, we have this licensing program. And at that point, we would probably push back a little bit and say, well, do you really have a licensing program? Are you licensing to podcasts now? Do you have actual plans, potential plans to go into look into podcasting? And this is, if this conversation, say, I am having with a hypothetical lawyer at a movie studio sounds expensive, yeah, this is how it starts to get expensive. Okay. How can we get out of this trap of the only defense to copyright infringement is fair use? But fair use is very complicated. It's an area that judges often get wrong, and you can only bring it up halfway through a trial. We can't afford this. How do we do it? So this is something I often do with smaller organizations, which really include almost every podcast organization, that balances expense and risk um, for the right kind of show. It won't necessarily work with every show. It certainly doesn't work with shows that aren't scripted and ad-libbed unless they have a pretty tight, set of bullet points. Um, but it's a training a lot like this, that we've already done, but it would be tailored to, the particular shows at issue. And it's taken an hour to go through with staff, with writers, hosts, editors, producers, so that they understand these issues before they arise. And that could be combined with a lawyer doing spot checking of scripts of episodes or of the actual audio of episodes. So if your editor knows more about fair use than they do today. If your producers know more about fair use than they know today, they can actually submit a script that's already annotated, maybe in Google Docs, so you already have your comments saying, please look at this, please look at that. And a lawyer can just blow through the script rather than taking the time, to read everything with the same degree of care. Or if you, as you get more and more facility with these things, the editor, the producer, the writer can pick up the phone or, send an email with, hopefully their bosses on copy because you don't want to run up bills without permission, asking the lawyer the specific question for anything that seems remotely close to the line. Because again, we want to be so absolutely clear on all three possible factors of the four factors that no lawyers from the media companies are going to bother us. So this is one way to do it. Issue training and issue spotting. Very quickly, because podcast is a global medium, I know that the write-up for this seminar said this will be for U.S.-based podcasts, U.S.-based law, but we'll look at a little bit. In England and former British colonies, you can think of Barbados, India, other places, it's called fair dealing. And it's a little different from fair use. It's easier to prove in some ways, harder than others. They have an across the board exception, I believe, for educational uses. I'm not a UK lawyer, but I just want to make you aware of how other countries might interpret these things. Typically, I'll find that things that are US based companies that own copyright tend not to go elsewhere and say, oh, you infringed in another country. They tend to approach you under US law from a US company. However, I have dealt with two companies who have had to deal with Australian and EU law, and one podcast company, TPA member, who was infringed on by a English company who claimed they were operating under fair dealing and absolutely were not. So we've had to apply these legal regimes. The EU is not the same type of legal structure as the US. There is no judge-made law. There's no doctrines where there's gray areas. It's just very clear. There's a list of exceptions. Are you a school? Yes, no. If yes, fair use. If no, not fair use. It makes these kind of seminars a lot shorter and a lot less fun. There are other countries that were very, affected by U.S. law in the 20th century, especially where the law is almost exactly the same as the U.S. So Israel, Malaysia, Singapore, South Korea, and Poland have pretty explicit laws that are much like U.S. fair use. But in general, oh, I don't know why that next slide is supposed to be. But I'm not an expert on international copyright law. I would say that is very rarely come up in the past 10 years that I've been working with podcasters. The two times, one of which you can read about in Pod News, a photo copyright sort of troll company contacted James Cridlin, and I can talk about this because he wrote about it. And because he is Australian, and if you go to the Pod News website, it gives an Australian address for him. They thought that Pod News LLC was an Australian company, so they were trying to threaten him under Australian law, which doesn't have some of the same protections as U.S. law. We ended up winning this case or winning this argument based on the DMCA, which we're not covering here. But the point is, we were able to demonstrate to this company that Pod News LLC is based in Texas. They are a Texas company. Just because James himself lives somewhere else, there are other people involved in this company, involved in everything they do, that are US based, come after us in US law. And by the way, here's why you're going to lose. Eventually, they left us alone. And again, in the case where a client of mine had their work infringed by a magazine in the US, they took a video portion of a podcast on a very hot news day. They put it on their newspaper's website with they just copied the video. They didn't link it. They didn't give any attribution. So they were costing my client a lot of ad revenue because this video became viral on the UK's site. We contacted them and said, you're absolutely not doing the right thing. You need to link through. And their first argument was, oh, fair dealing, fair dealing, fair dealing. And even with a cursory knowledge of fair dealing, we were able to argue to them that it wasn't. So I have a little thing here where I would like to, where I usually show some clips so that we can spin through, what we've learned about the four factors and judge them. But I don't think I'm going to do it here, partially because this will just link to a YouTube video, and I don't want you to have to possibly sit through any ads. It just doesn't work the same way over Zoom that it does in person. So I apologize for that. But these are two things. One is on TikTok. It is an elementary school teacher rapping one fish, two fish, red fish, blue fish to the tune of The Real Slim Shady by Eminem. It is absolutely hilarious. It uses a loop, the main hook from Slim Shady, and she reads the book and shows the photo, shows each page like she's just reading to kids of one fish, two fish, red fish, blue fish. The analogy there, I mean, the analysis is she's absolutely not protected by fair use against Dr. Seuss, or it's very, very slim. It is an educational use. She is an educator. She's reaching out to kids. I think the reason why Dr. Seuss didn't have the Dr. Seuss Theodore Geisel estate didn't have this taken down was it was during the pandemic. It's pretty cute. It might help sell some books, but that was just their choice not to. There's an idea that it is weakly transformative because she is presenting it in a very different context by wrapping it to the tune of The Real Slim Shady. And it is to some degree a parody because you can say that the meters and rhymes of Dr. Seuss are so repetitive and inflexible that you can actually use them to any song, right? I've seen YouTube channels that do that. So there's a weak case there, but it wouldn't be a strong case. On the other hand, if Marshall Mathers and Universal Music were to sue for her use of the loop, this woman would have a slam dunk. It was highly transformative. It's what's so funny about this video is she is aping the sort of aggressive manner of Eminem and his cadence and his delivery and everything else with this really sweet book, pretty clearly parodying Eminem. But let's judge me. Nancy, I'm going to try to play a clip from a trailer I did for The Man Who Calculated Death. And just jump on and tell me if it doesn't actually come through.
This is a story that began with
All
my
right,
mother's dying wish.
That is why we're going to be.
Nope. It came on after. If you want to go ahead and try it again.
Okay, sorry about that.
One thing I would like you to do, and any one of you can do it if you want.
Her last request, that my sister and I finish the memoir she'd started about her war-torn childhood in Germany.
It took me 5 years to write.
A turbulent era when her brilliant, enigmatic father was creating warplanes for the Nazi regime, including one revolutionary invention that would
My brother Heinz sings.
All right, very quickly, we're just going to run through what was in that part of the clip. The first thing was special effects of a hospital beat machine. That would have, there's no way you could argue that's fair use. Special effects libraries are designed for something like this, and we had a blanket license for that. The violin and the synth music, same. It was a sound bed. No matter where it came from, you know, it was used to create tension. It was used for the same purpose that the original creator made of it. Not fair use. The hospital room audio, that was owned by the creator. So not, not a problem. Didn't have to be analyzed as fair use at all. But let's say it had been used without permission. It's unpublished work. That would have made it a little less likely to win a fair use analysis. The special effects of the airplanes, what I mentioned before, is from a TV documentary about rockets. There we're getting a little close to the line, but this is not a documentary about rockets. It is a very personal essay about painful family history and atrocities during World War II. Not the same thing as this isn't the future great rocket documentary from 50 years ago. And most importantly, only used a few seconds out of a 30-minute episode or 30-minute documentary. There was then German state archive stuff from a newsreel. It's Hitler giving a speech. I usually skip through that. We've heard enough from that guy. That you would win under factor 2 in that case. Is not the kind of thing that's designed to be protected by copyright. And then we had some rocket sound effects from the same documentary. So this is, usually we have a show of hands for all this, but I give myself a clean bill of health. I think this was excellently analyzed under fair use. And you're not here to, you're not looking at me to say any different. I don't know how this, here we go. All right, that is the end of the presentation. Hopefully we have a little bit of time for a few questions for Q&A. I realize that was a lot. That was a lot of unnecessary attitude from me. I apologize. It's been a tough week. Thanks for listening. Don't get sued. And here's my contact information. Nancy, I'd like to unshare. And if there's any questions, maybe I can figure that out.
Wonderful. We do have a question. We have the chat box as well as one of the Q&A. Feel free.
Fantastic. Let's see how many participants I walked. Hey, there are more of you than there were when I started. Good job for sticking around, everybody. I'll go to the chat first. I'm going to reward not following instructions. Hi, Jessica. Miss Lindsay. Just curious, how does sampling in hip hop fit into this? Yeah, absolutely. Oh, and you mentioned the absolute worst example of it, Puffy, and I'll be watching. He barely changed a damn thing. I was so mad at the time. I was probably 17, and I thought he was a hack even then. Hip hop samples are obsessively cleared by music companies. And if you look on any sort of ASCAP listing for a song, if it's hip hop, there's like 27 different composers. Everybody gets paid a little bit of the royalties. Originally, however, this is where a lot of this analysis came from. Anytime there is the hospital beep song was signed. It was signed by. It was a written license, a digital license, and then the hospital room recording was owned by the podcaster herself. So she did not need to, get permission from herself. She's the one who made the recording when she knew she was doing this podcast. But back to sampling, yeah, anytime there's new technology, we're seeing this in AI now, the creators or a new art form, the new creators will say, hey, this is different. This is different than anything that came before. This is hip hop, where our modes of expression and African American vernacular, they require us to use samples in this way, and this is why you should allow it. Or this is AI. This is not the same thing. This is new. It happens every time, and sometimes copyright law will evolve a little bit, but usually the answer is no. This is still analyzed under the way we did it before. I hope that answers your question. But yes, hip hop is a really interesting case for fair use law. We have 2 questions. We're over time. Nancy, I hope you'll give me the chance to answer both these questions. Aaron, you'll be using a lot of classical music in your podcast, and older works are outside of copyright. Absolutely, anything that's generally 100 years. Or the life of the author plus 70, if it's not owned by a corporation, are no longer protected by copyright. Newly composed words, definitely, yes. All of the recordings, exactly. So this came up actually in the podcast I'm talking about now. If a symphony records a Beethoven sonata, Beethoven doesn't have a copyright, but the symphony itself, who hired the recording engineers and hired the musicians and made a sound recording, that tape itself is copyrighted. So you still need permission. We got around that on one part of this on this part of this podcast because they were playing the Blue Danube Waltz. Da, 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 da. To introduce a segment about Vienna, and that's very, very, very closely associated with Vienna. I didn't like this use, and I told the podcaster, you need to strongly criticize the Blue Danube Waltz as this. You need to say it's a little trite and treacly and should not be confused with the harsh realities of Vienna. Boom. Now it was criticism. It's a little bit more in depth than that, but that's the glib version. Anonymous attendee. Ooh. Just to be clear, under fair use for my music commentary podcast, what are the chances for someone to come after you for a few seconds of a song? Very good question. A few seconds, you'll be fine, as long as you're really discussing the song. What you should never do is play the full song. And your next question is, but Song Exploder plays the full song. Yes, and Song Exploder got real heat from music publishers for doing it, even though the musicians themselves were participating in every episode and loved being on Song Exploder and saw their sales spike after being on Song Exploder. They were not the rights holders. In this case, the music publishing companies controlled the compositions, and they were pretty angry about this. So I answered your question and gave a little bit more than you asked for. So I'm not sorry. Any other questions, anybody? Okay, I am looking at the chat. Someone tell me that the funny parts were actually kind of funny, even though it was a one-way communication on Zoom. All right, Nancy's on my side. Thank you, guys. All right, that's what I wanted to hear, Jessica. Thank you very much. Everyone have a wonderful day.
Thank you, everybody, for coming. We appreciate it.